think. Okay. Thank you for coming to the review session today, and we will be reviewing the course material we have covered this semester, except for case 8, because case 8 is the case we're going to do the quiz this Friday. So I will cover from case 1 to case 7, and also the course material we have distributed so far, including 3. I believe there are, you may try to be prepared that we will also cover some of the materials, including the court system, which is the first week of our class. And also, I think case briefing should be fine because we already do the case briefing for your group assignment. And we will also do the rule synthesis and the foundations of legal analysis for the third one, because it's and also an important material that covers the binding or persuasive authority, the types of authority, and the how do you do rule synthesis. If you have come to the class last time, we have a little exercise to let you synthesize several rules into one single rule. Okay, so let's get started. Let me share my screen. Let me know if you cannot see it. Okay, can everyone see my share screen with no problem? Okay, so that will be, we will firstly review all the quizzes we have done and also explain why the answers and the result are as presented. Firstly, for the first week, it's quite simple. We just want you to identify the information of the citation. We want you to identify the parties. And if I ask you to identify the citation or the reporter that was that includes that specific case, then that answer would change to A, right? 就是第一个是他的所收录的这个，算是判决汇编的期数哈。那 the second one is the court, the type of court. You can see this Second Circuit Court, which means it's a federal system decision, and it was decided in 2008. So that would be the information here. And the third one is the party involved in this case. Usually the one who is the petitioner or the respondent or the plaintiff or the defendant. So you need to see what my question is and to answer, pick the right one. Okay, the second one is asking the court hierarchy, which of the following court is the lowest court in the U.S. federal court system. The answer is the United States District Court for the Central District of California, because the title of the federal court, they are uniform in the United States. So you could distinguish by the format of the title. If it started with United States District Court, then you know that it's a federal court. And for the intermediate court, which will be covered later, it usually calls Court of Appeals or circuit courts. And there are 19 circuits in the United States, 19 circuits. So Ninth Circuit Court is the one that locates in California. You just need to know that it's an intermediate court. And our question would be the lowest court, so the answer would be B. Okay, so that's should be pretty simple so far. And let's start it with the cases. Case 1, it's the case Marbury versus Madison. It's a very fundamental case regarding separation of powers for United States. So what was the Chief Justice John Marshall's primary rationale for establishing the power of judicial review in Marbury versus Madison. Here we know that it established that the Constitution is the supreme court, supreme law of the land. So any legislative act that conflicts with it is invalid. And it is the duty that judicial department to say what the law is. So here, if any state law conflict with the Constitution, then it is become void. That's the case established. And the rationale here is that Marshall argued that Constitution is the superior paramount law if two law conflicts. Here, the statute passed by Congress and the Constitution, then the Constitution still prevails. Still prevails，就是当宪法跟法律有冲突的时候，在这个案子里面是奠定了宪法它的最高位置。And also the second question is, in this case, why did Supreme Court ultimately conclude it could not issue the writ of mandamus that William Mary requested? The answer is that because this act authorized the court to issue this writ in original jurisdiction was unconstitutional because it attempted to expand the court's power beyond what Constitution allowed. So the court, the rationale is that while Marbury was entitled to the commission, the Supreme Court do not have the jurisdiction to hear this case because it's the power of administrative party. So in this case, the court or the justice explicitly state that Constitution has the highest hierarchy in compared to other laws, and also there's a very clear distinction between administrative party and also the judicial organizations. 所以在这个案子里面，其实强调两点，就是司法跟行政是不能互相干预的哈。所以即便说他是有权来到这个职位，但是也不是由法院来发哈。他的意思是这样。Okay, so let's move on to the next one. Case 2, Brown versus Board of Education. It's a case regarding the equality of education. So the Supreme Court rejected the separate but equal doctrine, which was established before, primarily because the segregation in public education is inherently unequal, regardless whether physical facilities and other tangible factors are equal. That means because before this case, people or the court's decisions are if those schools based on race separate students based on race could be equal if other facilities are the same. However, from this case, the court established that no matter what, you cannot separate the students based on race. And the rationale would be separation is inherently unequal. 就是只要是依照这个种族来做区分，本质上就一定是不公平的。Okay. And their Chief Justice Earl Warren recently focused on intangible factors, arguing that state-sanctioned segregation would generate a feeling of inferiority in minority children that affects their motivation and mental development. So here it provides a reason why equal separation inherently unequal, because it will generate a feeling of inferiority for minority children. That's also the reason here. So it's quite simple, and I will just move on to the next one. For case 3, case 3 is a case regarding freedom of speech. In New York Times versus Sullivan, the Supreme Court held that the First Amendment protects the publication of all statements, even false ones, about the conduct of a public official, except when the statements are made with the answer is actual malice. Actual malice means that you know that the statement was false, and with reckless disregard whether it was false or not. Because if it's toward a private individual, then you will be count for affirmation. But if it's for a public official, the standard would be higher, because we want to protect public freedom of speech. So there's a trade-off between these two. The reason for that, let me see. Okay, yeah, the rationale here is the court asked for actual malice standards to prevent public officials from using defamation lawsuits to silence critics, because it is at times you might have some wrong information that made you present wrong speech, so that that way will protect people to speak more freely regarding public affairs. And here also, Justice Brennan's majority opinion emphasized the rule requiring critics of official conduct to guarantee a truth of all their factual assertion would be lead to a chilling effect. What was the core primary reasoning for protecting even erroneous statements? Because it wants to provide a breathing space that freedoms of expression needs to survive in a debate that should be uninhibited, robust, and wide open. So the question 2 is related to question 1. They all wanted to protect the speech that toward public official, but not private individual. Please be aware of that. And case 4, starting from case 4 to case 7, we cover the cases related to jurisdiction, and according to their years and times. The earliest one is International Shoe. International Shoe is a case that the court moved away from rigid present test of penal year. What's the core requirement established in this case for a state to exercise jurisdiction over a non-resident defendant? Because if a court wants to have a jurisdiction over a non-resident, before International Shoe, you need to have the defendant to be presently in the state. However, for a corporation or so for other natural persons, this rules or this standard seems not reasonable anymore, based on the very flourish economic activities. So the test have become minimum contact. Minimum contact means that this non-resident corporation needs to have some activities to have some enough connections with that state to be able to succumb itself to the jurisdiction. So here the answer is C. The defendant must have minimum contact with the foreign state so that the maintenance of such suit do not offend traditional notion of fair play and substantial justice. So starting from International Shoe, the Supreme Court standard has been changed to minimum contact, shifting the focus from physical presence to the nature of defendant relationship with the foreign state. And the second question also be related to the minimum contact, but in more specific elements. How should a court evaluate the nature and the quality of a corporation activity to determine jurisdiction? By determining the activities are continuous and systematic, it will count as minimum contact. So you need to analyze whether these business activities are continuous and systematic rather than single or isolated. So if it's continuous and systematic, and it will constitute minimum contact, so the court could have jurisdiction over that non-resident corporation. Case 5. Case 5 is Burger King. Burger King has a similar factual background with International Shoe. It's also an out-of-state party, whether you can establish the jurisdiction with a contract only. And the answer is no. An individual contract with out-of-state party alone cannot automatically establish jurisdiction. Court must look at prior negotiation, contemplated future consequences, and the term of the contract. So only one contract cannot establish jurisdiction. And the second question also relates to this. In this case, it has been established that the defendant purposefully directed their activities at the foreign state. What must the defendant show to defeat jurisdiction? So if the plaintiff have already proved that there is enough activity with the foreign state, and the defendant, you can counterprove or try to rebut by saying that, or by presenting evidence showing that a compelling case that the presence of some other consideration will render jurisdiction unreasonable and contrary to fair play. So here I'll explain in Chinese for a little bit. 在这边的话，就是说，原告当然是可以透过认为说被告他有一些非常程度的与该州的关联来强调对他的来正当化他的管辖，但是被告如果也可以去提出相关的证明说，如果有管辖的话，会对他产生不公正或不合理的现象，就是这边 contrary to fair play， 这边就是双方的攻防。Okay, so you could I'll leave the rationale for yourself. Okay. And case 6 here, Incurred Corporation versus Friend. It's an issue regarding how to define principal place of business. Which of the following best describe this? A corporation principal place of business is the nerve center. Typically means the place where its high-level officers direct, control, and coordinate the corporation's activities. Because in this case, there is some debate regarding how should we decide the principal place of business. Should we use the number of employees or the number of business? But the court thinks that these standards are not very practical, so they use the nerve center test. Second question also more deeply dig into this standard. What's the following reasons did the Supreme Court explicitly rely Hertz to adopt a nerve center test to more complex multi-factor test? Because the court still needs administrative simplicity and predictability because they are crucial for jurisdiction rule. They will help the litigants to determine proper forum. So you don't really want the standard to be too complex. So the court adopt nerve center test to ensure that it can apply easily and simply. Okay, so for the last case, case 7, in Goodyear Dump Tires versus Brown. This is the case that separate or advance the jurisdiction into more detailed division into general jurisdiction and specific jurisdiction. And if you want the general jurisdiction, you need to have a higher level of connection with that state. And if you just want to establish specific jurisdiction, then just related to this case would be enough. So here, the answer is that a state court may exercise general jurisdiction over a foreign corporation only when its affiliations with the foreign state are so continuous and systematic as to render it essentially at home there. So general jurisdiction, you need to have very high standard of or very high volume of activities to render such corporation essentially at home. 就是 general jurisdiction 跟 specific jurisdiction 的差别在于，specific jurisdiction 只能针对跟这个它目前这件争议有关的案子，它不能够管辖到这个公司的其他案子。但是如果是已经成立 general jurisdiction 的话，那就是只要跟这个公司有关的税务、雇佣等等任何案件都可以由这个州来管辖，所以它必须要一个比较高的标准。Okay, and this case was rendered by Justice RBG, who is very famous as a female justice. And he holds that the general jurisdiction over a foreign corporation is incredibly high. You need to make it essentially at home. And on the other hand, for specific jurisdiction, you don't need that high standard. So here, the second question would be how to distinguish between specific jurisdiction and general jurisdiction. And if you're only placing product into stream of commerce with expectations that will reach the forum, may support specific jurisdiction, but definitely not not able to establish general jurisdiction. Stream of commerce is also a principle that established earlier in other cases, which we're not reading them in this semester because there are too many of them. But this is the time that the Supreme Court has a more wide or more vague principle regarding establishing jurisdiction. But in Goodyear case, it has divided the jurisdiction into more into two different types, so that the dispute or the puzzle has been resolved because you don't need that high standard for specific jurisdiction. So stream of commerce can apply. However, if you want to establish the general jurisdiction, then the minimum contact that make the corporation essentially at home is the rule for now. Okay, the rationale will still leave to yourself, and that would be the case. Then next we will cover quickly the few course material we have introduced this semester. 那刚刚是 case 的部分，有没有什么问题？ Any question? If you don't have any questions so far, then we will move on to the other course materials. Firstly, the court system. The court system is the course material for the first week, and we introduced the structure of court system. There are two court systems, including federal and state, and also you might want to know that what are the cases that are should be in federal jurisdiction, when what are the cases that should be in state jurisdiction. For example, here cases arising issue of federal law or cases involving party from two different states, and the damage exceeds 75,000, then that would be in federal jurisdiction. And federal court system, they have a uniform title for all the courts. You need to be aware that how to distinguish those names of the courts so that you could know that it's a federal court or state court. For example, here, if it's a federal trial level court located in LA, and it will call United States District Court for the Central District of California. So from the title of the court, you know it's the first level, the lowest level of the federal court. And for the intermediate level, it will call United States Court of Appeals. And however, because there are many there are 13 court of appeals around the United States. So you can distinguish by the names, the titles, the United States Court of Appeal for the Second Circuit, Ninth Circuit, and you will be able to know that where it locates. There's a map over here. You can see that Ninth Circuit is around here, and Second Circuit is around New York State. And the highest court is called United States Supreme Court. I believe it's quite very familiar for you. In state court system, the names may vary, but usually they also have 3 levels, but they don't have a uniform title for the courts. And because we did not cover the function of trial and appellate court, so you may skip that for the exam purposes. And let's move on to the second one, rule synthesis. Rule synthesis is quite simple. It's actually presented some examples that how you distinguish rules and how you combine them. And here it provides a defendant entrapment by a police, the example, and to let you know that how do we interpret rules. And also later on, there is exercise including how do you what type of fact and what type of fact element can constitute felony mischief. And there are several cases, so you might want to have the ability to synthesize different rules from different cases and into one single rules. Okay, so that would be the rule synthesis, and you can skip the test for exam purposes because we didn't cover test. We only cover rule synthesis. And lastly, the foundations of legal analysis. It introduced what's the in statute and what are case law. This figure quite clearly describes that there's this very big distinction between enacted law and case law. And case law is also further includes common law and decisions interpreting enacted law. And here, if there is no enacted law, then there is a room for common law to exist. If there is already enacted law, then there is no room for common law to be present. 就是在成文法没有规定到的部分，当然就可以用案例法 common law 来形成。但如果已经成文法规定的部分，那就没有办法用 common law. But it could be decisions interpreting enacted law. It also part of case law. 就是稍微了解一下 case law 跟 common law 还有 decisions interpreting enacted law 的差别。And also there are some terms you need to know that common law and precedent. Common law is the law that constituted by with a large amount of precedent, and precedent is the previous court decisions, and if the court want to decide future cases, it must follow the rules or the principle of stare decisis. So you need to know the differences between these different terms. And next, the hierarchy of courts, we also cover some of them in the first course material, but this graph, I think, is very clear regarding their hierarchy and which one is binding and which one is only persuasive. If they are in the same system, and they are definitely binding on the lower courts. For example, Court of Appeals decision would be binding on U.S. District Court. However, it would not be binding on state trial court because they are different systems. However, for federal U.S. Supreme Court, it's the decision of it is binding on all courts, no matter it's federal or state, because it's the highest court of the United States. And so you can also take a look at the scenarios here, so you will have a better understanding of how it really works. Also, here it provides some examples regarding if an Alaska court asking for guidance, and their higher courts does not have any previous decision. It could also look into other state. However, it's only persuasive, not bound. It is not bound to follow that court's holding. Also, the type of authority here, it covers the court decisions are the primary authority, or I should say any type of law is primary authority, including statutes, constitutions, and secondary authority is the comments or editorialize about the law, including legal treatises, legal journals, articles. So primary authority is basically law. However, it's not necessarily binding. It might be persuasive, just as what I just mentioned. If they are not in the same jurisdiction, then it only has the power of persuasiveness, not bindingness. And there's also an example here to let you let you decide, or let you to think about how what's the power or the support is the strongest for an argument before state trial court. Then firstly, you could distinguish which ones are the primary source and which ones are the secondary sources. And between the primary sources, just as the last two, also you need to distinguish which one is binding and which one is persuasive. You can see the explanations after this scenario, and you will be very clear about how to answer this type of questions. And that would be all for our review. And do you have any questions regarding the course material I have covered so far? 有没有任何的问题？好。If you don't have any questions, so just remember, we will have a multiple choices test. It only has single answer. Please don't give me multiple answer for one questions. 就是我们会有选择题，但它讲 multiple choice 的意思是 single answer 请不要给我复选答案。然后 and there might be some matching questions, I believe will be quite easy, and you could try to match the right answer with the right column 有一些可能会是配合填充题，大概是这样。Okay, so if you don't have any questions, then that would be all today, and good luck with your exam. Take care. 那我们今天就到这边哈。好。